If you have seen headlines saying birthright citizenship is ending in 2026, you are not alone. This topic is spreading fast, and it is hitting a nerve for immigrant families, students, workers, and anyone planning a baby or planning travel. Here is the promise in this video. By the end, you will understand what birthright citizenship actually is under the 14th Amendment, what kinds of changes are realistically possible and which claims are not, and a practical checklist of what to do right now to protect your family from paperwork problems and rumor-driven mistakes. Now, before we go any further, we need to separate three different things that get blended together online. 1. The Constitution and what it says. 2. Proposals and political arguments about changing the rules. And 3. What agencies like USCIS, the State Department, and CBP can and cannot do on their own. Here is the part most people miss. You can have a loud national debate without an immediate legal change. A debate is not the same thing as a new rule that automatically applies tomorrow. So let us define terms quickly in plain English. Birthright citizenship in the U.S. is commonly linked to the 14th Amendment, which includes a core sentence. People born in the United States and subject to its jurisdiction are citizens of the United States. In everyday language, that has been understood to mean that most children born on U.S. soil become U.S. citizens at birth, regardless of the parent's citizenship or immigration status, with some narrow exceptions. The biggest confusion is the phrase "subject to its jurisdiction." People online argue over what that phrase means. Some claim it excludes children of undocumented parents. Others say it excludes children of temporary visa holders. Others go even further and claim it only covers children of U.S. citizens or green card holders. This is exactly why rumors spread. It sounds complicated, and people assume someone must have found a loophole. Now, what changed for 2026 based on your video idea is not that birthright citizenship has officially ended. What we have, based on the way this story is circulating, is a major discussion, proposals, and public pressure, plus the possibility of legal challenges and attempted policy shifts. Because the brief you provided does not cite an official law, a court ruling, or an agency memo, we have to treat this as a debate and reported proposals, not a confirmed change. That matters because your next steps depend on what is real right now versus what might happen later. So what are the realistic ways a system like birthright citizenship could be changed? There are only a few broad paths people talk about. One path is a constitutional amendment. That is extremely difficult and takes time. Another path is Congress passing a law that tries to redefine how the 14th Amendment is applied. Another path is a court case that asks courts to reinterpret the meaning of "subject to its jurisdiction." And another path people talk about is executive action or agency policy. But here is a key limit. Agencies cannot rewrite the Constitution. USCIS and the State Department can issue guidance about how they process documents, but if the underlying constitutional rule is unchanged, agencies are still constrained. This is where people get denied or delayed in real life, not because citizenship disappeared overnight, but because documentation, interpretation, or verification gets more strict when an issue becomes politically hot and heavily litigated. Now let us get very clear about who is affected versus who is not, because this is where fear spreads the fastest. First group, children who are already U.S. citizens, including those born in the U.S. years ago, and those who already have passports or consular reports of birth abroad if they were born outside the U.S. to U.S. citizen parents. The viral claim that citizenship can be instantly canceled for kids already born is usually not grounded in how citizenship law and due process work. Could government make some people's lives harder through documentation challenges or investigations if there is alleged fraud? Yes, that can happen in any system. But the idea that millions of people will wake up and lose citizenship by a sudden switch is not how this typically works. Second group, U.S. citizens and green card holders who are having a baby in the U.S. There is no credible reason, based on a general debate alone, to panic about your child's status. Third group, temporary visa holders and undocumented parents who are expecting a child or have a newborn. This is the group that feels the most pressure during a public debate because they worry about hospital paperwork, birth certificates, passports, social security numbers, and later, travel. The question many ask is, could my baby be denied a passport or a social security number if the rules change? The honest answer is, it depends on whether there is a real legal change, and if so, what the effective date is, what transitional rules exist, and how agencies implement it. But until there is an official legal change, the best response is not panic. The best response is preparation and careful monitoring. Fourth group, families planning future immigration benefits based on having a U.S. citizen child. This is also where myths cause real harm. Myth versus reality moment number 1. Myth: if a child is born in the U.S., the parents immediately get legal status. Reality: a U.S. citizen child does not automatically give parents a green card. There are future possibilities, but they are complex, depend on the parent's situation, and usually involve age and other eligibility requirements. So if you see videos implying you can solve status by giving birth in the U.S., that is misleading and can lead people into scams. Here is another myth versus reality that matters for 2026 rumors. Myth: a new rule in 2026 can instantly make babies born in 2025 not citizens anymore. Reality: even when laws change, they usually specify effective dates and how cases are handled going forward. Retroactive changes to fundamental status are rare, controversial, and typically challenged. That does not mean nothing can change, but it does mean you should be skeptical of claims that it will be instant, sweeping, and retroactive with no court fights. Now, why is this happening? And why now? Policy debates like this often surge when immigration becomes a major national issue, and when people are frustrated with border management, backlogs, and enforcement inconsistency. Another factor is social media economics. A headline like "Birthright Citizenship Ending" drives clicks, so it spreads. And during election cycles or major court cycles, people speculate about what the next administration, the next Congress, or the next Supreme Court term might do. Here is the key. The U.S. immigration system has multiple pressure points at once. Backlogs make families feel stuck. Processing delays make people feel powerless. When you add a viral constitutional debate, anxiety spikes, and scammers step in offering paid forms, special letters, or fake guarantees. Two groups are at highest risk in that environment. First, expecting parents who feel time pressure, and second, families who travel frequently and need passports and documents fast. Let us talk about real-world consequences, because even a debate can change behavior and cause problems. Scenario 1. Documentation delays. When a topic is controversial, agencies and offices sometimes become more careful, request more evidence, or apply rules more strictly. That can mean more questions, not necessarily denials. Scenario 2. Travel stress. If you are traveling internationally with a newborn, you are already juggling deadlines. If rumors make you second-guess the passport process, you might delay applying or make mistakes with documentation. Scenario 3. Misinformation at hospitals or local offices. Most hospital staff and local clerks are not immigration lawyers. A clerk might repeat something they saw online, and that can cause confusion. Remember, a birth certificate is a state record of birth, not a federal citizenship determination by itself. Citizenship documentation typically involves federal processes like a U.S. passport or other proof of citizenship. Now an example scenario, clearly labeled as an example. Example scenario. A couple is in the U.S. on a temporary visa. They have a baby in a U.S. hospital. They see a viral post that says, starting in 2026, their baby will not be a citizen, so they panic and rush into paying someone for a special citizenship package. They delay applying for the baby's social security number and passport because they think it is pointless. Months later, they need to travel for a family emergency, and now they are stuck because they waited, and the only real problem was timing and paperwork, not a new law. The lesson: when rumors spike, the practical risk is often missed deadlines and bad decisions, not an immediate change to the underlying law. Here is where people get tripped up. Understanding what documents prove what. A U.S. birth certificate shows the child was born in a particular place on a particular date. A U.S. passport is strong proof of U.S. citizenship. A social security number is a tax and identification number and is not the same thing as citizenship, though it is often issued to citizens at birth when parents request it. If your child is born in the U.S., the typical pathway is: get the birth certificate from the state, request the social security number if applicable, then apply for the U.S. passport if you need it for travel. If rules were ever to change, you would likely see official updates and new instructions on government websites, and those changes would be heavily reported and challenged. So, what should you do now? Without panicking and without taking irreversible steps based on rumors. Here is a practical do this and avoid this checklist. Do this. Save official sources and check them periodically. That means USCIS.gov for immigration benefits and policy alerts, travel.state.gov for passports, and official court or congressional updates if a case or bill becomes real and widely covered. Do this. Keep a clean folder, physical and digital, for birth and identity documents. For a newborn, that includes the hospital record summary, the state-issued birth certificate once it arrives, parents' passports and IDs, and any immigration documents the parents have. Do this. Apply for the baby's passport early if you anticipate travel. Processing times can change, and waiting until the last minute is the biggest avoidable mistake. Do this. If you are in any ongoing immigration process, keep your address updated with the government where required, and keep copies of everything you submit. Avoid this. Paying someone on social media who promises to secure citizenship or lock it in with a special filing. There is no magic filing that overrides the Constitution. Avoid this. Making big life decisions solely based on a viral clip, like canceling travel or moving money, without verifying whether anything official changed. Avoid this. Assuming that a U.S. citizen child fixes a parent's status automatically. That myth leads people into risky choices and exploitation. Now, if you are in a specific group, here are 2 quick targeted tips. If you are a green card holder or U.S. citizen expecting a baby, your focus should be normal documentation and timelines, not fear. Keep your own documents current, and if you are traveling soon after birth, plan for passport timing. If you are a temporary visa holder or undocumented parent expecting a baby, focus on accurate paperwork and reputable guidance. If you need individualized help, consult a qualified immigration attorney or a reputable non-profit legal service provider, especially before international travel. This is not because your baby's citizenship is automatically at risk, but because your own travel and status situation can be complex and mistakes can be costly. Now, what should you watch in 2026 specifically? Watch for 3 categories of real signals, not rumors. 1. Official court activity. A major case being accepted for review, a significant ruling, or an injunction that changes how a policy can be applied. 2. Congressional movement. A bill moving through committees, hearings, or actual votes, not just a draft mentioned on TV. 3. Agency guidance. Changes to passport instructions, citizenship evidence requirements, or USCIS policy manual updates. Here is the small detail that changes everything. Effective dates. If a real change ever happens, the effective date and the transition rules will determine who is impacted. People love to skip that and go straight to panic. Do not skip it. Myth versus reality moment number 3. Myth. If the debate is happening, that means USCIS will start denying everything related to newborns. Reality. USCIS is not the agency that issues birth certificates, and newborn citizenship documentation is typically passport-related through the State Department, not an immigration benefit petition. Different agencies have different roles, and confusion about which agency does what is a major driver of misinformation. Myth versus reality moment number 4. Myth. CBP officers at the airport can decide your child's citizenship on the spot. Reality: CBP can question travelers and review documents for entry, but citizenship status is a legal determination supported by documentation. If you have proper documents like a valid U.S. passport, that is strong evidence. The practical takeaway is, focus on getting the right documents, not arguing about viral theories at a border crossing. Let us talk about one more real-world consequence: scams. Whenever citizenship is in the news, you see fake lawyers, fake notarios, and paid services claiming they have inside information. A simple rule: if someone says they can guarantee citizenship, speed up your case for a fee, or they have a secret letter to protect your baby in 2026, treat it as a red flag. If you want help, use verified attorneys, accredited representatives, or reputable nonprofit organizations. So where does that leave us? Here is what we can verify versus what we cannot confirm based on the information in the brief. We can verify that birthright citizenship is rooted in the 14th Amendment and that the concept is a major legal and political topic. We can verify that rumors and claims about 2026 are spreading and causing concern. What we cannot confirm from the brief is any specific official 2026 rule that ends birthright citizenship, any confirmed effective date, or any definitive agency policy change. If you see content claiming it is already decided, ask, where is the official source, and what exactly changed in writing? If it is not there, treat it as speculation. Now let us close with a calm recap. 1. Birthright citizenship is tied to the 14th Amendment, and most children born in the U.S. are considered citizens at birth under long-standing interpretation, with narrow exceptions. 2. A loud debate about 2026 does not automatically equal an official change. Watch for concrete signals like court rulings, congressional action, or formal agency guidance. 3. The biggest near-term risk for families is paperwork errors, missed deadlines, and scams driven by viral misinformation. 4. Protect yourself with a document plan: birth certificate, passport planning, copies, and official source monitoring. 5. Do not make irreversible decisions based on rumors. Verify before you act, and get qualified help if your personal situation is complicated. If you found this helpful, subscribe and turn on notifications so you do not miss verified updates. And if you want, drop a comment with your situation in broad terms, like visa type and whether you are expecting or traveling, and I will cover the most common scenarios in a future video in a general, non-legal advice way.